has an option of heading to the courts should he disagree with the outcome of the National Assembly and Senate in the event he is impeached following an impeachment motion, which is to be canvassed next week. Now, according to law scholars and lawyers who TV47's senior political reporter Elizabeth Mutuku interviewed, opined that the parliamentary process is a quasi-judicial process and thus doesn't bar Gachagua from seeking justice in the judiciary since it's the custodian of the Constitution of Kenya.
As the clock ticks to Wednesday next week, when the Senate will probe the impeachment motion facing Deputy President Rigathi Gachagua, the way forward after the parliamentary process has divided legal opinion in country on whether the embattled second in command has a lifeline in the corridors of justice. The debate was ignited when former Law Society of Kenya President Nelson Harvey opined that the Constitution does not anticipate a judicial intervention in the removal of Deputy President from office and that the DP will cease holding office when the Senate upholds the decision of the Senate to impeach Gachagua. But according to senior counsel John Haminwa, the DP has more than one avenue to get his case heard in the courts.
The High Court, that is right. He can go to court to seek a remedy to show that the process of law has not been followed. There have been grave irregularities. There have been, we can allege that there have been bribery and etc. Yeah, he can do so.
He can still. At the moment, there are over 20 petitions in the courts challenging the impeachment process, with the Chief Justice now asked to form a panel of 3 to 7 judge bench to hear the weighty legal matters surrounding the process, which some argued could face doldrums due to fact that Parliament used a law set to impeach county government officials to impeach a national government executive member.
Not how people remaining in offices when it has emerged very clearly that people are very unhappy with the ministry that the individual is heading or with the office that the individual is heading. If he finds that people are very unhappy with what he is doing, let him put in a letter of resignation and go. He can always come much later on.
Haminwa now proposes a change in law which calls for nomination of DP before an election, which he says could bring more legal problems ahead. Haminwa's opinion on what next after the parliamentary process has been echoed by former Attorney General of the Republic of Kenya, who opines that decisions of quasi-judicial function of the parliament can be challenged in courts and are largely only limited to summoning of interested parties. Article 165 of the Constitution 2010 gives the jurisdiction to courts on anything done on the authority given by Constitution is amendable by courts from High Court, Court of Appeal and Supreme Court.
After all, presidential power is shared, in practical terms, is shared between the president and the deputy president. So if someone has been a deputy president for 2 terms together with the president, when the incumbent goes away, he should also go. The same should apply for the position of the governor and deputy governor.
Tonight, a long road ahead as according to lawyers, the court process is just the beginning of full constitutional process. Elizabeth Mutuku, TV47, Nairobi.